case briefs, and so much more. LSData's got what you're looking for.
Retrials can often be predictable, largely mirroring the initial proceedings with the same mistakes made, but a looming retrial for United States v. Glynn aims to take a different approach. The case revolves around Glynn, a defendant facing murder charges linked to racketeering, drug trafficking, and firearm use. In a unique turn of events, the defense has questioned the scientific reliability of ballistic analysis, arguing for the inadmissibility of such evidence. Their challenge contests decades of established legal practices and has significantly changed the playing field leading up to the retrial scheduled for September 29, 2008. What led to this extraordinary development? In the first trial, the prosecution sought to introduce an expert testimony from Detective James Valenti. Valenti was confident that the bullet and shell casings recovered from the crime scene came from Glynn's firearms. However, Glynn's defense aggressively countered this, claiming that ballistics identification, an evidence-gathering technique dependent on the assumption that each gun leaves unique markings on bullets it fires, lacked scientific sufficiency. In the initial trial, the court maintained a measured approach, allowing Valenti's testimony but limiting it to the assertion that it was more likely than not that the bullets and casings came from Glynn's guns. Now, in a rare display of judicial flexibility, the court plans to uphold this ruling in the retrial. The new regulation reflects the court's careful analysis of ballistics as an evidence-gathering practice. While it acknowledged the existence of certain assumptions, such as the transfer of unique gun markings to bullets, it also recognized that these haven't been empirically proven. Hence, the court allowed for the possibility of a firearm match being more likely than not, complying with Rule 401. As the court rolls out its revised protocol, the Glynn retrial promises to serve as a battleground where the legal acceptance of such forensic science could be potentially upended, if not modified. In a criminal justice system increasingly wary of unreliable testimony, the court's new guidelines drill home the need for juries to be aware of the limiting conditions shaping what can be presented as evidence.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.